afternoon, everyone, and welcome to this pre-examination meeting. The meeting concerns the appeal by the Park of Keir partnership against the refusal by Stirling Council to grant planning permission in principle for a proposed development on land at Park of Keir in Dunblane. I'll refer to the Park of Keir partnership as the appellants from now on today. Just to recap what the proposed development would comprise, it's a new tennis and golf centre and a number of elements including a museum and visitor centre, indoor and outdoor tennis courts, golf course with clubhouse and practice areas, hotel with leisure and conference facilities, multi-user sports pitch and outdoor play area, cycle trails and footpaths, new access roads and junction, new tree planting and landscaping, SUDS, that's a sustainable drainage system, pond and associated drainage works, car parking and servicing, and enabling housing development. My name is Tim Bryan and I'm a reporter within the Scottish Government's Planning and Environmental Appeals Division, which you'll know as DPEA. And I've been appointed by the Scottish Ministers to conduct a public inquiry in this case and to prepare a report and a recommendation to Scottish Ministers as to whether or not to allow or indeed to reject the appeal proposals. I should also introduce also here today my colleague Ewan Murray to my left, also Pauline Hendry, who will have been greeting you as you arrived. Can't see where Pauline is. And also Chris Warren, who's also a reporter who's sitting a few rows back, and he's here today solely to observe the proceedings. So Pauline's returned. So that's Pauline Hendry from DPA, just to introduce my colleagues. Okay, firstly, can you hear me okay? Is that okay? If at any stage you can't, please let me know, because there's little point in us speaking unless everyone can hear. What I'd ask is everybody round the main tables to ensure that they speak to the microphone, but I'm told to speak, don't shout. The system doesn't work well if you over-project, but just make sure your microphone is switched on when you're speaking, and equally important, switch it off when you're not speaking, because that can interfere with the overall sound. Before I ask people to introduce themselves, I've got one or two housekeeping points to raise. Firstly, it's a first for me anyway, is today's meeting is to be broadcast to the internet, so it's going to be webcast today. And that's why Ewan is sitting behind such a battery of technology on my left. So the idea is that anybody who's not able to attend the meeting will be able to watch it live or watch a recording on the DPA website. Or indeed it's possible that somebody who attends today but wants to recap something they've forgotten will be able to go back and use the recording, which will be available to view on the website. So webcasting is part of a strategy to increase the public access to the planning and appeals process, and the idea is it will make it easier for individuals in particular to keep up to date with proceedings. It's a pilot project, so we're finding our feet at this stage, and in that period for a year we're going to be recording as many of the hearings and inquiries as possible, including the Park of Keir inquiry, which we're here to discuss today. Just to mention that the camera today will be directed towards the main parties, the people sitting around the tables here, including myself. But due to the nature of the layout of the room, it's possible that audience members in the front rows may feature in a background shot of some footage. I'm hoping that people are comfortable with that. If not, you could always secrete yourself towards the back of the room and that would avoid that arising. I should also mention the arrangements in the event of a fire, and that's if the alarm rings which would leave the room by the nearest exit, and you can see them well marked, one behind me here, two at the far end of the room and one to my left. And then the idea is we would then assemble outside in the street, Station Road outside. Another plea to switch off mobile phones, or at least put them on silent, please. And the final plea is if you would add your name and address to the attendance list, which is circulating around the room. Now, hopefully polling will have intercepted most of you as you have come in, but if you haven't, please at some stage add your name. It's very important for us to be able to keep track of the people we need to send information to. So thank you in advance for that. I should say at the outset, as should be clear from the correspondence you've received, that the purpose of today's meeting is purely to discuss the arrangements and the procedures that we're going to follow in the consideration of the appeal. I'm not going to be hearing any evidence on the proposals this afternoon. Nothing for or against. That's not the purpose of today. It's purely looking at the arrangements for the inquiry. And I'm hoping that you'll all have received a copy of the agenda. If not, we have some spare copies which we can circulate. And I'm assuming that the agenda covers the issues that we need to discuss, but there will be an opportunity at the end of the meeting if there's anything to do with procedure which you're not clear about or you think we need to discuss, by all means let me know then. And I'd hope that the meeting can be concluded within a couple of hours, but I'll largely be in your hands on that point. I'm not going to ask everybody in the room to introduce yourselves because it would take a while and you're all signing the attendance list, but I will be shortly asking the main parties to introduce themselves. I will be producing a note. That's my note of the matters discussed and agreed at the meeting. It won't be a note of everything that is said. It'll be a note of the issues that have been agreed, which we need to record on paper, if you like, or electronically, so that everybody knows exactly what's expected of them, both in the run-up to the inquiry and thereafter. So hopefully that will take some of the pressure off some of you if you're wanting to take voluminous notes. Okay, that's the introductions then, and I'll perhaps ask the main parties to introduce themselves, so starting with the appellant's Park of Keir partnership.
Thank you, sir. My name is Neil Collar. I'm a solicitor and a legal associate of the RTPI with Brody's LLP, and I'm accompanied today from my left down the table, Alston Burney, John Handley and Victoria Smith.
And could you introduce each of these representatives? Tell me what their roles are. Thank you.
Thank you, sir. Mr. Burney is representing the partnership. John Handley is the planning consultant, and Victoria Smith's part of my team at Brody's.
Thank you, Mr. Collar. And who's representing Stirling Council here?
Okay. Afternoon, my name is Ian Strachan. I'm Chief Governance Officer of the Council. My colleagues to introduce themselves.
I'm Jay Dawson, Principal Planning Officer of the Development Management Team.
I'm Jane Brooks-Burnett, Senior Planning Officer with Stirling Council.
Right, thank you very much, and welcome to all of you. Can I now ask the objecting organisations to introduce themselves? I'm conscious here that there are three main organisations on my list, if you like. I've got the Dunblane Community Council, I have Bridge of Allen Community Council, I also have Residents Against Green Belt Erosion Rage, who are also represented today. And perhaps you could explain how they're all fitting together for the purposes of the inquiry. Is it Mr. Shaw, or who's representing the Rage today?
Hello.
I'm Inge Bullen, and I'm a member of RAGE, Residents Against Greenbelt Erosion. We're a voluntary group who have been campaigning to protect Park of Keir for 25 years.
Okay, thank you. I'm particularly interested in where you fit in relation to the community council. Are there either of the community councils represented today?
Phones aren't working. We're not hearing. People can't hear. Phone's working. The volume is going up. That's it.
Is that working? I'm David Prescott. I represent Dunblane Community Council. I am a community councillor.
Thank you. Is there anybody here from Bridge of Allen Community Council? No. Okay. So,
can I just say I have had a dialogue with Bridge of Allen Community Council. They weren't sure whether they would get representation here today, and I will be feeding back to them the outcomes of the session.
thanks. That's very helpful.
Chair, can I just introduce myself as well? So my name is Mark Ruskell. I'm a councillor for Dunblane, Bridge of Allen Ward. I gave evidence at the original hearing. I'm also MSP for Mid Scotland and Fife.
Thank you, Mr. Ruskell. I was going to invite you to speak. At this stage, I'm trying to make a note of the organisations who are represented today. Is a representative of Tennis Scotland here?
Good afternoon, Brian Dodds, Chairman of Tennis Scotland, representing the governing body of tennis.
Any other organisations rather than individuals who are represented here today? Was that a full roll call for the moment? We will be coming to individuals who want to take part in the inquiry later on, but just wanted to make sure I've got all the main organisations properly recorded. Thank you. Okay, just a very brief bit here on procedure before we go much further. The procedures for hearing planning appeals changed following the Planning Act in 2006, which came into effect in 2009. Now, the reason I'm telling you this is that those who may have been involved in previous inquiries may have been involved under a previous system, and that's why I need to explain the system which now applies. Under the current system, there's no longer an automatic right to a public inquiry or hearing. And in appeal cases where the reporter considers he has enough information on the file to make a determination, he can do so without further procedure. But in other cases where the reporter requires further information before he can take a decision, or in cases where you need to test the evidence of the parties or particular elements of the case, then the reporter can decide which issues he requires further procedure on. And that means, in practice, that the reporter can seek written evidence on certain issues if he needs it. He may, in other cases, require evidence to be explored through either an inquiry process or a hearing process, and I'll explain the difference of those shortly. But in this case, having assessed the information on the file, which is quite voluminous, I decided that I had enough information on a number of issues, but that I needed additional evidence on other issues which I think are likely to require an inquiry or hearing process. And one of the purposes of the meeting today is to explain the procedures I'm suggesting will apply and to hear your views before I take a final decision on the procedures we're going to adopt. So you'll have seen from the agenda that there are a number of issues that I think need inquiry or hearing sessions. And I'll just quickly recap what they are. Firstly, do the proposals comply with relevant green belt policies? Secondly, do the proposals represent sustainable development? Then what would be the impact on sport, recreation and tourism? What would be the net economic impact on a local and national scale of the proposed development? Is the proposed housing development necessary or justified to enable the other elements of the proposal to go ahead? And finally, what conditions and or legal agreements would be required if permission was granted for the proposed development? And I'd underline on that point that this is a standard procedure at inquiries to consider what conditions would be attached in the event of consent being granted. In no sense does it prejudge the outcome. So my initial thought on these topics is that with the exception of conditions, the other topics would be best considered at a more formal inquiry session where the witnesses would be open to cross-examination rather than at an informal hearing session, which is essentially a round table discussion which is led by the reporter. And this is partly because of the number of parties involved, and partly because I think that some of the topics would lend themselves to cross-examination. But I'd emphasise that if a topic isn't on the list that I've just read out, it doesn't mean that I regard it as unimportant or that in any way it's going to be disregarded. It just means that I'm happy that I already have enough written material on the topic, or that it may be an issue that is best considered on site rather than inquiry. Because clearly the decision-making process involves both a consideration of written material, consideration of what happens at the inquiry, and also what I see on site and what I make of what I see on site. So I should also emphasise that all of the written material that's already been lodged, including the most recent petition and the numerous letters of representation, all of these will be fully taken into account in my report to Scottish ministers and in the decision that they ultimately take. So you don't have to be involved in the inquiry in order to have your views considered. But before I get into who might be involved in the inquiry process, are there any questions arising from what I've said so far? Yes.
Thank you, Chair. I do have a question in relation to the scope of the oral evidence that will be presented at this inquiry, and it relates to the direction that was given by Scottish Government ministers in relation to this appeal. The letter which identifies the direction says that the direction is because of the potential economic, tourism and sporting benefits of the proposal to be an issue of national importance. Can you clarify for me exactly what weight is going to be given throughout this inquiry process to those matters that have been raised by the Minister?
No, what you've quoted from is the reason why Scottish ministers recalled the application for the determination What I now have, though, is an application before me to consider and make a recommendation on. And in considering the proposal, I will consider all the issues. I'm not approaching the proposal with any precondition or any prior view on the subject. I'm coming to it fresh, and I will read what I read, hear what I hear, and make a recommendation on that basis. I don't know if that helps.
Fine. So, although there were issues which the Minister didn't identify in that statement, in your mind and the way you'll be approaching this inquiry, all of those issues that are material are of equal weighting, and therefore the issues specifically identified by the Minister are relevant, but they're not the sole consideration that you have in conducting this inquiry.
I can't say at this stage which issues will have the greatest weight, because I haven't heard the evidence yet. But all I'm saying at this moment is that all of the issues will be considered equally. At some stage, later down the process, I will have to work out from what I've heard which issues are more important than other issues. That's not a decision that I could or would wish to make at this stage. So I'm approaching it in that light. Any other questions at this stage?
Sir, it might not be a question at this stage, perhaps it would be more usefully dealt with later, but the first two bullet points on your list, do the proposals comply with relevant Greenbelt policies, and do the proposals represent sustainable development? It would be useful if you could explain in a bit more detail the scope of evidence you were anticipating under those headings. It might maybe be best illustrated by thinking about professional witnesses. In other words, under Greenbelt Policy Sustainable Development, were you anticipating it being largely a planning policy issue, or might it go into, for instance, landscape and visual impact?
I think that's quite possible that it would. The first question was, do the proposals comply with relevant Greenbelt policies? If an element of the Greenbelt policy relates to landscape and visual, then I'd expect evidence to help answer whether or not it complies with Greenbelt policies. So I wasn't intending to be prescriptive on precisely what evidence parties brought to bear in order to answer those questions, but I would have thought that the policies would take you to the nature of the evidence that needs to be presented. If not, then by all means, if you would like to write to DPA following today, a copy of your correspondence would be on the website, then I would attempt to break down the question into its component parts, but I was deliberately keeping it quite wide in order for the parties to decide themselves how they wish to pitch their evidence.
If I could maybe approach it from a different direction then, you mentioned that there were some issues that you decided you had enough information. Would that be something that you could perhaps supply the parties after today with a list, because that would help guide us on the issues that you felt you didn't need to hear evidence on in the sessions?
Yes, I'd happily do that. I mean, I can, if you would like, I can give you an indication of that just now. The issues that I wasn't going to ask for evidence upon were whether the proposal is consistent with housing in the countryside policies, whether there is a need for smaller homes in the area. This is my shorthand. This is one of the council's concerns that are expressed in their reasons for refusal. Possibly, depending on the full answer to your last question, a landscape and visual impact might be something that I could deal with without further evidence, on the basis that I will have, and we'll come to this later on, full material allowing me to make an assessment on site. Another issue which I wasn't going to ask for extra evidence on was the alternative sites that might have been considered, the transport impact, road access, road safety issues, the impact on the historic environment, including ancient monuments, listed buildings, designed landscape, impact on woodland, designated nature conservation sites, ecology, habitats, protected species, impact on services, for example schools, railway stations, the parking issue, health centre, impact from runoff from the development, that's impact on Allen Water, and the more wide questions of compliance with provisions of the development plan overall and consistency with national policies. Now, manifestly, these are not issues that I have reached a judgment on, but they're issues which I think I will have enough material in order to make a judgment on. And so, to come back to your original question, whether landscape and visual impact needs to be part of the Greenbelt discussion depends on the precise terms of the policy, which I have to admit I've not brought with me today. Does that help at all?
Thank you, sir. Yes, I think that gives us enough to take away and reach our own assessment on the technical evidence we would look to bring forward.
This equally applies to any of the parties. If arising from today, there's still a question arises where you think, I thought I understood what the reporter meant, but now actually writing my evidence I don't, then please contact us at that stage and we'll try and fill in any gaps, or if there isn't enough information, we'll try and supply whatever you need in order to produce your evidence for the inquiry. Okay, can we now have a look at who might be involved in the inquiry process then? I'm assuming, as far as the inquiry session is concerned, that the appellants, Park of Keir Partnership, the Council, the Community Council, and Rage and Tennis Scotland, and also Mr. Ruskell would want to be involved in the inquiry. Am I right so far? Can I just get you each to confirm?
Sorry. Yes, that's correct.
Yes, sir.
And Rage clearly want to be involved in the inquiry.
Yes.
Yeah. What would be helpful to me now then is to get an indication, and that's all we can expect today, of the number of witnesses that the main parties would be likely to lead at the inquiry session, and the scope, roughly the scope of their evidence and how long it might take. Now, I appreciate that it's difficult to estimate timings, but we need to work off something in order to programme the inquiry. Firstly, the appellants, Mr. Kohler, if you could.
Thank you, sir. I would estimate that the appellants would have 4 witnesses for the inquiry session. One issue that we would need to take away and discuss would be possible duplication with Tennis Scotland. Sorry, the difficulty is because I'm talking to the reporter, so thank you for the reminder. I would anticipate 4 witnesses. We would need to compare notes with Tennis Scotland about possible duplication, but for present purposes it's probably better to overestimate, and then if we need less time, so much the better. On a general rule of thumb of each witness taking maybe half a day, that would be 2 days.
And that's taking account of cross-examination by various parties, is it? Or?
Yes, sir. Because as you're aware, with the system of advanced disclosure and the shorter precognitions, the cross-examination is actually the bulk of the time.
And can you give me an indication of the topics that they would be covering? Obviously, we know the topics for the inquiry, but if you, for example, will there be planning consultant witnesses? Will there be experts on tourism, or what disciplines will they come from?
Taking the bullet points on your agenda on Greenbelt policies and sustainable development, from what you told us about the matters that you didn't require further evidence on, I would anticipate Mr Handley dealing with those issues. On sport, recreation and tourism, as I said, potential duplication with Tennis Scotland to be discussed through, and to some extent that also duplicating with the economic impact. Certainly on the economic impact, calling the author of the outline business case, Mark Kumara. So the 4 is a slightly flexible 4, if you see what I mean. It's a little hard at this early stage to be too precise about which individual would fit under which heading.
Thank you. So for the sake of today, if we said up to 4 witnesses, taking an estimated 2 days, that would cover it?
Correct, sir.
Okay, what about the council?
Yes, thank you. We'd estimated around 3 witnesses and in the region of 1.5 days.
And can you give an indication of who they might be and what they'd be covering?
Well, as matters stand, we were just anticipating council officers. We weren't anticipating any external consultants or the like.
And would it be yourself who would be leading the council's case?
No, we get external legal support.
So you get external
legal support on that.
I should have asked Mr. Cole, will you be leading the case from the appellant's point of view?
Yes, sir.
And what about Rage? Will they be represented by... would you pass the microphone, Ben? Thank you.
Hello. Can you hear me? Yes. We really don't know at this point. We are, as a voluntary group, we're here to represent individuals if they wish to use us. So we're trying to coordinate things. We don't know at this point because a number of individuals have made objections and haven't contacted us yet, so we don't know whether we are representing just ourselves or a larger group. So we can't really tell. I also know that there's Mr. McGarvey here who's wanting to be involved, and he's not in our group, so we're not speaking for everyone.
Yeah, would you switch your microphone off a second? Thank you. What I was also interested in was whether who would be actually presenting the case on behalf of RAGE. Would you have an individual who is asking questions on behalf of RAGE, or would you be sharing your own talents, as it were, and representing the organisation?
We haven't decided that yet because we really weren't too sure what form this will take. Also, we have very few funds, so we don't want to be having to pay someone. So we're waiting to hear from you, really, what form it's going to take. There might well be various members of our group speaking. At the moment, there is uncertainty about the dates and people being on holiday, so we have that issue as well.
Okay.
Oh, sorry.
Just before you come back, can I just ask a question on that? Do you mind switching that microphone off just a moment, thanks? Are you envisaging then that the organisation would themselves, if you like, divide up the task, and each of the tasks would have what I would call a witness, somebody giving evidence at the inquiry on that particular issue? Somebody from RAGE would cover the points that I've mentioned now will be dealt with at the inquiry session. Is that how you see it?
Yes.
Thanks, that's very helpful. Can you just bear with me? Sorry, I just need to make a note. I need to make sure I keep up with you. Just excuse a second.
Hello, can you hear me? Okay, fine. This is the third public inquiry we've been involved in, and the last public inquiry we had a QC, Gordon Steele, and depending on the outcome of today is whether we go down that route again.
Okay, that obviously is a decision for yourselves, but I appreciate what you're saying. You need to first hear what form the inquiry is taking, and then decide exactly how you're going to run your case. What I need to take from today is an indication of who's taking part and the extent to which they're taking part, so we can schedule the inquiry. So that's helpful anyway. Can I now ask what involvement the Community Council's proposing to take?
At the moment, we're not sure quite what involvement we will have, but we are a completely unfunded organisation made up of volunteers, so that does rather set the scene, I think. I will be leading for this. Dialogue will obviously have to take place with my colleagues as we develop. I am not sure yet that we will have witnesses to present, but we clearly will have our own views to present, so I'm not quite sure how that will play out in the process. And as I say, I can't commit to anything because I would need to spend some time with my colleagues to make sure they were happy with the direction in which we were going. I hope that's satisfactory. I suspect colleagues at Bridge of Allen will say much the same.
Yep, I think probably the word witness conveys something beyond what I intend it to mean. anybody who's actually giving evidence to the inquiry is strictly a witness. What I'm taking from what you're saying is that the Community Council wants to take part in the inquiry, and it's possible also that your neighbours in Bridge Allen also may want to take part, and as part of that you'll want to give evidence to the inquiry, and that's helpful as an indication at this stage.
Cross-examine, I think, as well. Okay.
Indeed so, yeah. That's there's if you like, the plus and the minus of taking part. The minus is that you're cross-examined, the plus is that you can cross-examine. So you would be a full party to the inquiry, as indeed would the other names that we've collected so far. That's helpful. So I don't think we're going to be able to estimate the timings as yet, because we don't really know the extent to which Rage and the Community Council will be involved, but we can flag up that they do intend to take an active part in the proceedings. And Mr. Ruskell, you want to also take part in the inquiry?
Yeah, I would anticipate being called as a witness, along with the objecting organisations.
As a witness?
As one of their witnesses, so I'm happy to be marshalled by the objectors as a witness.
Okay.
Yeah.
So you're going to be one of Rage's witnesses? That's your expectation?
That's my expectation, yeah.
That's fine. Okay. Mr. McGarvey, you're wanting to take part as well?
Good afternoon, sir. Stuart McGarvey. I'm representing on Bathie Developments Limited. I would like to take part in the inquiry. I'll be concentrating on one element only, and that's enabling policy. I will be giving evidence against that, and I would expect half a day.
Thanks, that's very helpful. Okay, we've heard then who is taking part from the local organisations. We also need to find a way for individuals, other than the ones that have already spoken, to make a meaningful contribution. I'd say at the start, I don't want to discourage individuals from taking part, but there are always advantages in grouping together with other people who have the same point of view. There is a great deal of advantage presenting a coordinated case. It avoids unnecessary duplication of effort on one point, and it also enables pooling resources. I would also really underline that there's little value in repetition at inquiries, so there's sometimes a misapprehension that if you say something often enough it gains force. It doesn't. The point made well once is normally sufficient, and having said all that, I'm not wishing to discourage people from taking part. But what I would suggest is that if any individuals want to take part, they consider whether their point of view is already represented by Rage or Community Council. With that in mind, are there other individuals who we haven't itemised so far who would like to take part? It was Dr.
Christina Heath. She might join up one of this I'm Dr. Sheila Heath, and I'm representing her today. She talks about
Okay, that's very helpful. I'll note her down as an individual objector, and it'll be entirely up to her whether she wishes to join in with Rage. That's entirely her choice. Anyone else, either here today or representing somebody else who's not here?
Hello, Rosemary Hunter. I have made a personal submission, but I'm part of Dunblane Community Council, so if the Community Council agree with the issues I have raised, then I would potentially join up with them. If there are areas outside the things they wish to discuss, then I would probably present myself. And I'd be interested to focus a lot on the business case.
Thanks very much. I'll put you down as an individual objector at this stage, and if you choose to join with others, that's obviously fine. Anyone else that I haven't recorded?
I'm Susan Stone, I've been involved with Rage and before it spoke. Probably coordinate any objection with them, but I'd like to register a right to object on my own score, representing a family trust if necessary. If that's all right.
Absolutely. That's it. I wasn't intending to stop people from taking part. I was just, I suppose, selling the benefits of combining with others.
Yes.
But if you have any...
I'm more likely to combine with Rage than not, but I just wanted to reserve the right to make my own point if I had to.
That's absolutely fine. Thank you very much. I'll put you down as an individual objector at this stage. Okay, that's very helpful. As far as the hearing session is concerned, I've already mentioned that we'll have a hearing session in order to consider conditions that might be attached in the event that consent is granted. I'd envisage that to be a roundtable discussion, which I will chair, and that will inevitably involve the appellants and the council, and community councils would want to be involved, community council singular at this stage, or possibly plural, would want to be involved. Rage, I imagine, would want to be involved in that discussion. And are there any other organisations or individuals who would want to be involved in that discussion? You're obviously most welcome to join in if you have a contribution to make. I'll assume... Tennis Scotland, okay. Anyone else? Okay. So, I hope somebody else has been tossing up the number of days that we've accumulated for the potential inquiry. We're talking about something that's likely to take a week or possibly a little bit more than that, I would suggest. So I think we probably ought to earmark a couple of weeks at the moment, within which we may only need 4 to 6 days. I don't know if anyone else has a view on likely timings, but that's my sense. Mr. Kohler, do you have any thoughts on that?
I was thinking along the same lines, sir, that it feels at the moment as though it might be a little bit more than a week. Unlikely to be as much as 2, but conscious that in terms of capturing people's diaries, it's better to be pessimistic. I suppose maybe just to ask, would you be envisaging just sitting 4 days in a week, or would you do a whole 5? Because I'm conscious quite often inquiries don't sit on a Monday, for instance.
Well, I'm entirely relaxed about inquiry sitting on a Monday. Traditionally, the Monday was kept clear if the inquiry was relatively inaccessible and parties had to travel a long distance, but I certainly don't think Dunblane qualifies as inaccessible. So I'd be happy to sit Monday to Friday if that's what the parties wanted. Any thoughts from the council side on the likely length of the inquiry, or indeed whether or not a Monday?
No, in terms of length, that seems fine in accords with our thinking. And Monday, no, I'm absolutely happy with a Monday.
deal with the more difficult point, which is finding a slot for the inquiry. I'm obviously expected to find a slot as early as reasonably can be found, consistent with allowing enough time for the parties to prepare and for the exchanges of material that's required in advance of the inquiry. And that's why I alighted on the week beginning the 29th of August and the following week, or failing that, the week after that. So that would be my favoured date, would be starting on the 29th of August. I'll need to check round the room now to check how the parties are placed with those dates, starting with the appellant.
Thank you, sir. The appellants would be available for any of those 3 weeks.
What about the council?
The 6th of September is problematic for us. Otherwise, it looks okay because we've actually got a planning panel that day. So in terms of officer representation.
Okay, so I'm sure we could work around that. It was just a single day. What about Rage on your part?
Hello. This poses a problem for us because some of us have already booked our holidays and we really would not be available until at least the middle of September.
Right, that could present a difficulty. Are you then by suggesting then that there's nobody available, or that it's just that some of your team would be available and others wouldn't?
Some would be available and some would not.
Sorry, some would be available and others would not. Certainly I wouldn't be here, and neither would our secretary.
Right, but given that the nature of the inquiry will be for each organisation taking part to nominate individuals to give evidence on behalf of that organisation, would it be possible to find people within the organisation who could speak on their behalf within those weeks?
We would prefer the date to be later because we have been given very short notice on this and we need time not only to allocate our own preparations, but we do feel that in view of the importance of this case that other people might also require extra time.
Sorry, is that extra time to prepare? Is that as distinct from people who might be away on holiday?
Combination of both.
This is obviously an unknown for us, but effectively less than 2 months to be in a position to do something we haven't done before, which is prepare evidence and then receive other people's submissions and read them, dissect them, does seem a fairly significant task. So I am concerned about our ability to perform our duties properly and correctly in the timescale. You may be able to reassure me that it won't be that difficult, but it does look quite a big task for a very small group of people, largely 2 or 3 of us, to be able to pull all of this together, and literally ourselves trying to do the best we can without the ability of professional support and guidance, other than a small amount of available guidance on procedure that we have available to us. So I am not concerned about the length of time of the inquiry, although that itself is significant, 2 weeks, but whether we are going to be able to do our job adequately for our community in the timescale that we have to prepare for it. If that's the timescale we set, we will do the best we can.
Okay, I was also going to ask, I was really more thinking of, are you available during that period? There's a separate, I'll come to the pre-inquiry exchanges shortly, which will tell you what would have to be done between now and then. But at the moment I'm just focusing on, will you have the personnel to represent the Community Council during those dates?
At the moment, we have those dates free, taking the cue from the information in the previous pack. So, yes, we can have somebody, but I shall need a holiday afterwards.
I think I have a slight concern around it in that, for example, if I was part of this working self-employed full-time, to have to take 2 full weeks out at what is actually quite short notice could be quite difficult. I don't know whether there's a possibility to spread it out over a slightly longer time frame, i.e. 3 or 4 weeks, 2 days each or so.
What you need to bear in mind is that not everybody has to attend the inquiry every day. So one way we can accommodate third parties who are, if you like, those who are not being paid to attend the inquiry is to set a particular day which suits third parties. And then you can keep in touch with the other days of the proceedings by either through webcast or through colleagues on the same side of the argument, if you like. So there are ways and means of keeping in touch with what's going on, but not feeling obliged to attend every moment of the proceedings.
As far as the governing body of tennis to represent and give evidence on tennis and the sport issue, the governing body will be obviously impacted by holidays and annual leave at that time, but we are comfortable that we'll be able to ensure the appropriate cover during that time for the appropriate witnesses.
Okay, anything else?
I was just going to ask, sir, whether you have a particular deadline for completion of this inquiry. Is there an externally set deadline for this that you need to be mindful of?
The answer is no. I'm obliged to hold the inquiry as soon as I reasonably can to allow the steps that need to be pursued between now and then, and to give people a proper opportunity. And the timings which I was going to suggest for the different stages are devised with that in mind. So we do quite a number of these inquiries, and over time we have assessed how long each of these stages takes. And there's certainly no intention of corner cutting in this case. The timings that I'm suggesting are quite, inverted commas, generous in relation to the minimum timescales that might be imposed. Obviously, we're trying to balance the need to progress the case, determine it as soon as possible, with the needs of those taking part. So that's part of the reason of the meeting today. Any other views on dates?
You mentioned
Yeah, my sense was that the appellant was okay with any of those 3 weeks. Am I?
That's correct, sir, yes.
What about that as an idea then? The first 2 weeks, now just to be clear which weeks we're talking about. We're talking about the weeks beginning, the 5th and the 12th of September.
Subject to my comment before about the 6th of September, those 2 weeks seem fine.
The Council is okay with that, the appellants are okay with that. What about the other parties? Will that be a compromise?
Could we move it forward to the 12th of September? One of the reasons is that the lady at the back, whom I met recently, the person she's recommending is in fact away at Rome on a conference, and she is one of our most fervent supporters. She's also an academic and from Oxford, and we would want her to speak. And she won't be available until about the middle. She will be available on the 5th of September. Right. I think.
I'm wondering then, from what we're saying, that if we delayed it just by that 1 week to the 5th and the 12th of September, whether that would help.
Sorry, am I correct in thinking you're moving it to the 12th?
No, I'm suggesting the 5th. I'm suggesting the 5th and the 12th. Now, within that, if you wouldn't mind switching mic off a sec so people can hear me, thanks. Within that, it's possible to programme the wage evidence in the second week, if that was easier for your organisation.
Okay, we'd go there.
Okay, well, thanks for your help on that. I think that's probably the constructive solution to always the most difficult element of these meetings is finding a date that suits people. So, clearly, everyone has other commitments in their lives other than public inquiries. Let's just come on then to what we call the prior disclosure of cases. This is a key element of the process, and that's the requirement for each of the people taking part to disclose their case to the other parties well in advance of the inquiry, in accordance with the timetable that we fix. The point of that is there's no scope for ambushing, there's no scope for people turning up at the inquiry with something new and very exciting that others haven't seen. It's fairness is what guides the process, and fairness involves the parties knowing in advance what the other side's case is going to be. So with that in mind, I'm going to suggest that the parties who want to take part in the inquiry session lodge inquiry statements within 28 days of the meeting today. Now, the purpose of the inquiry statement is to set out the particulars of the case they're proposing to make on the matters that I've specified that I want to cover at the inquiry. Also the documents that they're going to rely on, and by that stage a list of who is going to speak at the inquiry session on which topic. So if I just follow through the process, you'll see how it unfolds, and then I'll obviously invite comments at that stage. As far as the documents which are going to be referred to at the inquiry, I'm going to ask for those to be submitted at least 28 days before the start of the inquiry. And that gives everyone the chance to see what the other side is putting forward by way of evidence. And lastly, anyone giving evidence at the inquiry will have to lodge a precognition, which is a written statement of the evidence they're giving, which is normally read at the inquiry. And that would have to be lodged at least 14 days before the start of the inquiry session. And they're limited to 2,000 words, so we're not looking for anything voluminous. We're looking for quite a concise statement of the case on behalf of that individual. What I would say for those that take part in these sessions quite often is don't attach appendices to your precognitions, please. Those would have to be lodged at the normal time as documents. So, as far as the schedule of conditions is concerned, the Council has already tabled a draft schedule, and the appellants, I believe, have lodged their alternative or their critique of the Council's schedule. So I'm not anticipating that I'd need any further written material on conditions prior to the hearing session. What I would say, though, and this is a plea to the main parties, is to consider the scope for agreed statements so that the sessions can focus on the matters in dispute which are relevant to the proposals before the Scottish Ministers. So that would mean that the appellants and the Council should consider whether there's any basic facts or data or assumptions which can be agreed in advance to avoid wasting time in the preparation of cases and the preparation of presentation of evidence and cross-examination at the inquiry. So examples of that might be statements of the site history, it might be relevant planning policies, it might be technical methodology. For example, if there was evidence that could be agreed on the methodology of the economic impact assessment, for example, that would save unnecessary time at inquiry. So that's just a few suggestions. I don't know whether the Council or the appellants have any other ideas of things that they might be able to agree on to clear the decks for the main arguments at the inquiry.
Quite happy to take that offline, sir, and have the discussion. I think there probably will be some additional matters that we could agree on.
Yeah, I have to deal with that way.
Okay, thank you. Anything arising from that's if there are any agreed statements, those should be lodged as documents at least 4 weeks before the inquiry. So the normal rules of prior disclosure apply so that everyone can see what has been agreed between the parties, if indeed anything has been agreed. So, any questions on the sequence that I've just set out? I'll obviously explain this in the note of the meeting, and you'll be able to get further information on our website. The circular, which I've referred to, is a very helpful source of guidance here, which again is accessible through our website. But anything that jumps out at you at this stage that's not clear on the sequence of disclosure prior to the inquiry. Or if anything else occurs to you, we'll obviously be able to answer nearer the time. So, we next need to think about the sequence of evidence actually at the inquiry. So we need to work out in which order the parties are going to be presenting their evidence. The normal course of events would have the appellants going first, then followed by any supporting evidence. So that would include Tennis Scotland. They would come, if you like, together with the appellant, because they're basically, if we're drawing battle lines here, they're basically on the same side of the fence as the appellants. And then would come the Planning Authority Stirling Council, and then would come the objecting organisations community councils, RAGE, and any individual third parties would come last. Now I'm hoping that that's okay as far as the parties are concerned.
Can I just confirm, just understanding here, obviously the Governing Body of Tennis is representing the best interest of tennis, not the best interest of the appellant necessarily.
I wasn't meaning to suggest something different. I was merely saying that here we're looking at, in order to sequence the evidence, we need to work out who is opposing the development, who is supporting the development. I'm understanding Tennis Scotland to be basically in support of the development. If I'm wrong, tell me. If I'm right, then they're best placed in the sequence after the appellants, if you're happy with that. Okay? Next question then that arises, would it be helpful or necessary to set aside a day for individual third parties to speak? Or, if it's still possible that all individuals will join together with the organised objectors, that's probably not so helpful. Any thoughts on that? Yes, I think where at inquiries where there's a large number of third parties, individual third parties, then it's sometimes helpful to have a day devoted to those individuals. We could easily do that. Is that what people think would be helpful? Happy to do that if is that a good idea? Well, happy to go with that. That would, I would suggest, would be a day in the second week, because you would want to have heard the appellant's case before you make your objection to it. So I'm happy to make a provisional date now, if the main parties are happy, for a day sometime in the second week. Now, if we don't know at this stage how long the inquiry is going to go into the second week, I would suggest we earmark a date at the beginning of the second week, just to avoid us coming back if the inquiry is already finished, as it were. So the Monday or Tuesday of the second week would seem to be the obvious time to me. Is that okay for the point of view of those taking part? That would be the 12th or the 13th of September. Any preference for one or the other? Well, let's make it the 12th then, shall we? Thanks, that's a very helpful suggestion, thank you. Okay, just a brief word then on what happens at the inquiry. During what we refer to as evidence in chief, each of the witnesses would be invited to read their precognition and then would be open to cross-examination by the opposing parties. And after that, there'd be an opportunity for what's called re-examination by the witnesses, advocate or representative. So that would be an opportunity to ask, if you like, further questions of your own witness, arising from the questions that have come up in cross-examination. And when the evidence is all complete, then each of the participating parties would have the opportunity to make a closing statement, often known as a closing submission. And those would then be heard in the reverse order, which means that the appellant's closing statement would be heard last. Now, the other thing to say on closing statements is these are very important documents from the reporter's point of view and also minister's point of view, so it's very helpful if they are provided in typed form, and that makes sure that I don't lose any of the sense in my note-taking. It's quite important that I have a very clear idea of what the main parties' positions are at the end of the inquiry. So if necessary, what we tend to do is if the evidence finishes on a particular day during the inquiry and the parties say, can we have an extra day in order to prepare our closing statements, we may then take a day out. I may use that to conduct a site visit and then we come back for the closing statements. But I can't program that today because we don't know, obviously, exactly how long the inquiry is going to take. But as I say, it's not essential, but I think it's very advisable to provide a typed version of your closing statement if you're proposing to make one. So, we need to discuss... Yeah, sorry.
Just on the closing submissions, if I could put in a request, quite a lot of the inquiries I've been involved in recent years, the closing submissions have actually just been done electronically, which does save everyone turning up. I don't know that we maybe need to decide that today, but if I could just put that in as a request.
That will be an option, and it really, I will rely on yourselves to decide, I think, at the inquiry whether you wish the closing statements to be delivered at the inquiry so that they're read out and we can all hear them, or whether, as it often happens, the evidence closes and then the parties ask for more time to prepare their closing submissions, which are then circulated electronically, as in we get the written closing submissions to a timetable after the inquiry. And it depends really on a number of factors, including how fast the inquiry is progressing. If we're running out of time and we've only booked the whole till Friday, let's say, then the parties may say, well, let's just exchange them electronically afterwards. But it's, you know, I'm happy to take views on it today, but I think it's probably something we need to decide nearer the time. Okay, so we need to discuss where the inquiry is going to be. I'm assuming that the parties are happy with where we are at Victoria Hold as a venue. It seems to be very convenient, very central. It's next to a railway station. This is assuming it's available in the weeks that we're looking for accommodation. But is everyone happy that this is a good venue? In which case, just on the off chance, sorry.
From what I understand, it does have pre-booking, so we might not be able to use it. This venue might not be available for a 2-week slot.
In which case I'll rely on your local knowledge as to what a suitable alternative would be in the area.
Possibly the Dunblane Centre.
Can you tell me a bit about it and the accommodation it offers?
I'll hand over to my colleagues.
The Dunblane Centre is just a short walk from here, and we've held inquiries there in the past.
We're told it's a short distance away from here, and inquiries have already been held as a venue. I don't know how many people it can accommodate.
I think it's
Well, that I have to say is a bit of a draw, because we do find during the inquiry there's quite a lot of material that we all of us will have to cart around from day to day, and that might be an advantage. Is everyone happy that would be a suitable venue if that's what's available? So, the way it will work day to day is that the inquiry and hearing sessions will sit from 10 in the morning till around 4:30 to 5 in the evening, depending on how we get on. I would not tend to break during somebody's evidence who is almost finished. So maybe it will go on a bit longer, some days will go on a bit shorter another day, depending where we've got to in the evidence that we're dealing with. We break for it normally for about an hour for lunch. Between 12:30 and 1 we'll probably break for lunch. If we are struggling for time, if we need to catch up time, then we would, with the agreement party, start earlier in the morning. But generally it'll be we'll aim for a 10 o'clock start, and that allows people travelling from a distance to comfortably get here. I need to say something about the documents for the inquiry. We'd certainly encourage everyone to submit their documents and precognitions electronically. These are obviously displayed on the DPA website where everyone can see them. And I'd also encourage parties to use Word documents when producing lists of documents, inquiry statements, precognitions, draft conditions, because those are easier then to incorporate as appendices in the report. It's just a lot more efficient than having to retype 20 pages of a schedule. So that's a minor logistical point. However, although we would encourage everything to be lodged electronically, I would still ask the main parties to produce their documents in hard copy form for my use at inquiry. It is quite difficult to rely entirely on electronic means to access particularly larger than A4 documents at inquiry. Yes.
Could I ask how many copies you are requiring?
That's what I was going to ask yourselves. Who would, of the parties, would seek to have a hard copy of the other side's documents? Or are they content just to take everything electronically?
I think, sir, electronically would probably suffice. I'm just mindful of avoiding overburdening people, but there might be an extent of wait and see, but the best way around of doing it might be to say electronically, and then we could ask if there were individual things that we felt we needed a hard copy of.
What about that as an approach, just to encourage everyone to submit electronically, but to ask for anything in hard copy which you're struggling to read or use electronically, and we won't really know that often until we actually see them on the screen. Does that sound like an approach? Is everyone happy with that? Because there is a risk when you, an organisation becomes a party to inquiry, that you will suddenly find that you are absolutely swamped with large boxes of files, very few of which you'll necessarily want to read. They won't necessarily relate to the bit of the case that you're interested in.
I think one of the difficulties of being an unfunded organisation is that when you do get something, it becomes extremely difficult to produce a hard copy. And I think that's a point that, I accept the point that you don't want to be overburdened, although there will be an awful lot of stuff in the email anyway. I think I would quite like the Keir issues to be in hard copy, so for myself and the other community councils, so that we were in a position to be able to go through and decide what was necessary. Now, if there's going to be that volume of material produced, then it raises a question as to how much we can interact with it. And I have seen enough experience of being big organisations attempting to overwhelm small organisations by just producing so much information. And perhaps I should say so much data, because often it isn't information. It's very difficult to get to the bottom of it. So I think I would certainly reserve the right to receive fair amounts on behalf of the Community Council in hard copy. And I think the question is how is that best delivered? I'm more than happy to deliver what we do electronically, and again we prefer to do that rather than in hard copy for the same reasons of how do you produce it.
I fully understand the difficulty that we're in, but isn't the suggestion made, doesn't that resolve it, that each of us can see what we're faced with and decide what out of that we want to have in hard copy form?
I think I'm saying we will want some in hard copy. I'm just making it clear we will want some in hard copy. I'm not entirely sure what at the moment. And then there's a question as to response time if we want it in hard copy, because that then reduces your ability to read it, review it, digest it, and consider what you do next. So there's a key point as to how quickly the hard copy arrives.
Yeah, that is understood, but the counter to that, of course, is that it will be there to read on the website. It's just that there is some material that will be easier to navigate in hard copy. Some will be more difficult to navigate in hard copy. I speak from experience.
Okay. Sir, could I maybe just add, just for the avoidance of any confusion, the appellants have lodged a fair amount of documents already. So if there were any of those documents you wish to see in hard copy, that's something that could be addressed in the coming weeks to avoid the delay, just picking up the point you were making about time being a limited resource.
That's a good point. The question then is how do we access and who do we access it from?
Can I just make another point that may help on this? And that's, I was going to also discuss where there should be a full set of documents on deposit for parties to scrutinise. It's usual at inquiry to have one hard copy set, which is at a local library, which people can study at their leisure within, obviously, the opening hours of the library concerned. And I was going to confirm with yourselves where the best location would be. I presume Dunblane Library would be the obvious place for that sort of material to be left so that people could study it. I'm envisaging that would include the planning applications, supporting documents.
Dunblane or Bridge Allen Library would be equidistant between the sites, so it depends if Bridge Allen are happy.
Right.
Is it possible for it to be in both Bridge Allen and Dunblane?
I think we need to find a single location, because otherwise you're multiplying the amount of paperwork by two. Or is it felt that it's essential that they need to be in two locations? I mean, clearly the inquiry is going to be in one location. Other thoughts on that? What the council think on that?
I don't think Dunblane and Bridge Allen are particularly far apart, that either location would be an issue, I would imagine, for the parties.
Quite useful to have it in both, for some for people to walk to and some for people.
It's it's really largely a matter for the council and the appellants whether they think they could readily provide the copies and supply them in both locations. If they say that's fine, then obviously I'm happy, but it's more than would normally be required.
Yes, I think from the point of view of the management of the documents and so on, we would ideally like to keep it in one location, just for ease of access and for ease of time as well.
If Bridge of Allen are particularly keen to have it, I don't think Dunblane Community Council mind coming to Bridge of Allen for that, but the only point I would raise is if the inquiry itself is in Dunblane and you want to go and review a particular document over lunch, then you're half a mile away rather than 2.5 miles away. So,
to me, if it was going to be in one location, the obvious location is Dunblane, for exactly the reason you've given. Also, the idea, once the inquiry started, I would envisage the council bringing the documents from that location to the venue so that people could, who are attending the inquiry, could browse the documents as things arose.
We're happy with Dunblane.
Okay, I think we'll stick with Dunblane Library then. Okay, we're almost there. As far as the site inspection is concerned, I've already made quite a lengthy inspection of the site on my own, and that was to familiarise myself with the site and the surrounding area. But most likely at the end of the inquiry, or possibly if there's a gap during the sessions, I would expect to make a further inspection in the light of what I've heard, which the parties would be welcome to attend. So I think it would be a good idea to have an accompanied site inspection either during or at the end of the inquiry, and we can only make firm arrangements for that when we know how the inquiry progress is going. So what I would say then is if anybody wants to contact DPA about the appeal or the inquiry, they should phone Jane Robertson, who is the case officer, and the telephone number you'll get on the correspondence that you've had together with our address. But the best way to keep in touch with developments is through the DPA website, which again you'll have the link, but all of this will be contained in the note of the meeting. As I said at the outset, I'm going to be preparing a note of the points that we've discussed and agreed today, which will be sent to all of those of you who have signed the list and those who have expressed an interest in the inquiry. It will also be posted on the website, and parties will have 14 days, if you like. Those who are wavering about whether to take part will have 14 days to confirm whether they wish to do so. And the proceedings will also be advertised in the local press. Now, I'm going to ask you shortly whether there's any questions that you've got to raise before we close the meeting. There's a point that I want to raise, though, before we close, and that's I'm really addressed to Mr. Collar. I'm noting that the application has changed from originally one that included 100 houses to 19 houses in the proposals that are before Scottish ministers. But to my knowledge, there isn't an updated landscape and visual impact assessment. And I'm wondering whether that is proposed. Indeed, that might be very helpful to have an up-to-date LVIA. Is that something you've given thought to, Scholar?
It's not something that we've given any thought to, sir, but we'll certainly take that away as a suggestion, and I think we would be able to give you a provisional indication on that in advance of statement of case deadline. So I would anticipate we should be able to get you an indication within the next 7 to 14 days, say.
Right. In the event that you did prepare a further LVIA, that would have to be slotted into the process that we've just described to make sure that everyone had the opportunity to respond to what would be new information. So that's something that we would have to consider at that point. But it might be in those circumstances that I would have to send out a procedure notice and give the opportunity, a formal opportunity, for the other parties to respond. So I suppose the assurance we'll have to give today is if we do get any new material arising from what I've just mentioned, then we'll make sure that it is, number one, made public, and number two, that an opportunity is given to respond or make any further comments in the light of the new information. Right, is there anything else that anyone wants to raise about the procedures for the appeal? Yes?
Mr. Bryan, on a similar vein, in terms of the documents provided by the appellants, I note there's an amended design and access statement, an amended outline business case, but I can't seem to see an amended planning statement. Taking on board your point about the 100 houses down to 19, I was wondering whether such a planning statement would be provided.
Is that something that you had considered, Mr. Collin?
No, sir, and I think, as with the LVIA, we will take that away as a thought and respond in due course.
One further point, Mr. Bryan, I also noted in the list of documents POK 15.1a and POK 15.1b.
What are the references you're giving?
15.1a and 15.1b, and these relate to the Aberdeenshire Enabling Development Policy and the Aberdeenshire Supplementary Guidance Enabling Development. And it's really an understanding of are the appellants relying on those documents, and if so, where they're related.
Can you answer that?
Well, I'm slightly puzzled, sir, because my recollection is that the relevance of those documents is explained in our appeal statement, or grounds of appeal. I can't quite remember what it's described as.
Okay, I think you flagged up the point, and obviously that will be an opportunity for the appellants to consider that point and, if necessary, respond. So thank you for that. Any other points?
I've just got a small one. I just wondered, given you're piloting the webcasting at the moment, is that something that you'll be having in place for the inquiry sessions, just so members of the public are aware?
Yes, that's the idea.
It's perhaps gone back a stage, but it's maybe for my clarification. You've used the term sustainable development. It seems to mean, as much as anybody wants it to mean, has lots of different definitions. Do I take it that you will be using the 4 outcomes of the Scottish planning policy as the guide to your consideration of this, or are you going to issue some better advice as to your definition, what the definition you're going to use in the process to decide on sustainable development?
Well, I'm going to give you the same answer I've given earlier, really, which is going to be down to the parties to respond to that point, but I would expect in responding to the question that they will pay very close attention to the Scottish planning policy, which I think is the document that you're referring to. So there is quite extensive commentary on that within SPP, and I'm sure that will play a central part in the discussion on the point. Okay, any other points to raise? Okay, Well, if there's nothing else that we need to discuss just now, I would just repeat that if anything else occurs to you, by all means, write, phone or email DPA and we'll try and answer your question. But meanwhile, I'll just thank you all very much for your assistance today and I'll formally close the meeting.